Vercammen. I'm an attorney in Edison, New Jersey, and later one of my colleagues, Dave Solenko, who's a financial advisor, will be joining us. So we have about 45, 50 minutes to go over estates, wills, powers of attorney in New Jersey. So, believe it or not, by the way, New Jersey has decreased some of the taxes. Who would think they would do that? The prior year, New Jersey did away with the New Jersey estate tax. However, there's still a federal estate tax, but that only applies to the people that are in the back row here that have more than $12,700,000. Everyone other than that doesn't have to pay. Oftentimes, when people will say, Kenny, why do I need to have a will? I'm married. Doesn't everything go to my spouse? Well, if you have children from a prior marriage, no. But even if you have children from the same marriage, that's not really doing planning. That's like having a house without homeowners insurance, like after you pay off the mortgage. You want to do some planning, because if you don't have a will, or the will was not done correctly because someone used some cheap form, number one, the procedure to distribute assets becomes much more complicated. What that means is that all the children have to agree upon who's going to be the administrator of the estate, and all the children have to sign a renunciation in front of a notary, and that has to be filed with the county circuit for some additional fees, and there has to be what's called a bond taken, a surety bond. Let's say one of the children doesn't sign the renunciation, then the family typically has to file a complaint or a show cause and go in front of a judge and ask that the judge appoint a family member as the administrator of the estate. So, we love the judges here in Middlesex County. The judges now handling our probate matters is our East Brunswick guy, Judge Roger Daly, that used to be the prosecutor here 30 years ago. So, but anytime you go in front of a judge, plan on spending $3-4 grand in court fees, costs, etc. Also, if there's no will or it wasn't done signed correctly, state law determines who gets your assets, not you. More and more people are saying, hey, do I have to leave the money to all my kids equally? Can I give it to my grand? It's your right typically to do with your money what you want. By not having documents properly done, you're losing the opportunity to possibly reduce expenses down the road. But more importantly, when you don't have a will, it oftentimes causes aggravation and arguments amongst family. And when people are grieving, they don't need one more thing. And they also don't need the one that wasn't involved, wasn't helping, that all of a sudden, goes and says, okay, I'm going to be in charge. You're going to be in charge. You haven't been around for 10 years. You never took mom to the doctors. You never did anything. You shouldn't be the administrator. Well, I want to be the administrator. So everyone got to think about it. If you don't have your, who do you want to get your assets? Who you don't want to get your assets? And certainly, who you don't want is the United States government or the state of New Jersey. And when there's grandkids, think of, okay, we want to set up a clause that says you're not getting their money until they're at least 18, unless it's been used for college, because, not 18, either 21 or 25, because 20-year-olds don't do anything smart with money. And they also get influenced by other people. So, I always tell people, and it's not just me saying it, the county surrogate will tell you, beware of online stuff, because the surrogate says almost all their problems they see is where someone tried to do something themselves and it wasn't signed correctly, and then they're trying to explain to the family, no, we think of the surrogate as a fancy name for the will clerk. Let's see, us people over 60 remember when we were younger and our fathers used to tell us how to show us how to change our oil. We don't do that anymore, and so it's best to have documents done. But believe me, one of the few good things that happened out of the COVID thing was to make things easier, more complicated. The old way was, you get on the phone and you call up the law office and they say, okay, we can see you in 4 weeks. We're going to mail you this form, fill it out in a pen, and then bring it in, and you've got to come in on this day, this time. Well, half the time I couldn't understand people's handwriting. Or my client today had 4 names in his name. It was Rajahan, let's see, Rahan, Rahiga, more than some of that, and his wife had a different name in the card. So a lot does it nowadays. So here's how things are easy. Let's see. Typically, the law office will email you a short questionnaire, and they're going to ask you, okay, type in your name, type in who's executive 1, who's executive 2, who's going to get your stuff. Let's see, and then you do a spell check, you send it in. Let's see, then typically the attorney will call you up and say, okay, yeah, I recommend this, this, and this. You can also type in your any questions you have. And then the next thing the attorney typically will do is say, okay, the fee is this. People pay they mail in a check or they pay online through the credit card. And then the documents are prepared and sent to people. Probably now that, 2.5 years ago, people had to take off of work or make arrangements to come into the law office to sign. Nowadays, 90% of people says, listen, I'm gonna print it out and go and sign at the UPS store or the notary at where I work. In this way, I don't have to take all time from work, and I'll make it easy. So, I've got attorneys now are trying to make it easier for people, and because it's easier to kind of think about, okay, who you want when you're in the comfort of your home, rather than all of a sudden right real fast in the reception area of a law office. Try to make things as easy as possible. So the confidential will questionnaire is that the attorney's not allowed to discuss it with anyone except for you. And that's led to arguments between me and my wife over the years, because she would say, hey, how come you didn't tell me my Uncle Ernie came to see you? And I would say, the guy goes, none of your business. The guy goes, it's a confidentiality rules. And say, he goes, well, he told me this. He can tell you, but I can't tell you about anything that goes in. Now, we also can't discuss the matter with family members. Now, I'd say trying to assist people. Sometimes the person who is typing the form is not the client. It's one of their kids trying to help out mom or help out dad or help out Uncle Joe. And Uncle Joe might not have he may only have an iPhone. He doesn't have a computer. Okay, no, listen. But I got to talk to Uncle Joe, and Uncle Joe has to tell me what he wants, not Uncle Joe say, whatever my nephew wants, that's good to me. Logistically, you'll also put in who's executive 1, who's executive 2. We tell people, never have joint executors. It's the worst, because it makes twice as much work. We've had clients that they got 2 kids, they could be twins. It goes, listen, if there's joint executors, that means 2 people got to go and qualify with the county circuit. Then 2 people got to sign every paper. 2 people got to sign every check. 2 people got to do everything to sell the house. 2 people got to go to the closing. They could be twins living together, but why create more work? The idea is to make it as simple possible. So there's an executive 1 and an executive 2. That's it. If the client said, I feel bad, I don't want to pick one over the other, and goes, I'm going to help you out. We're going to write their names on 2 pieces of paper. I'm going to shuffle them around, and I'm going to close my eyes and go like this, and that's going to be number 1. And that's worked out. We do have to be concerned, though, as attorneys for conflicts of interest, because we always get calls. Again, mom, dad, Uncle Joe needs a will, needs a power of attorney. Okay, we're going to email you the question. I need to talk to. Well, they can't really talk there at this facility, that facility, or recently they had a stroke. If they can't tell us what they want, we can't do the documents. I'd say, also, if I think it smells, I won't do it. That's just me, because I always believe in doing the right thing. So, for example, what does it smell? Well, all of a sudden, someone says, oh, Dad wants to do a new will and leave everything to me. Well, how many kids are there? 3. Let's see, a quick example, if someone can't come in, the old days, if someone couldn't come in or had difficulty, we would adopt. Now no one's coming in because of COVID, whatever, but if they have medical issues, just to protect everyone, we want to know from the doctor saying that they're okay to sign a will voucher, and the doctors agree with that. It creates a little more work, but you know, the quick example is like Johnny calls up, oh, mom wants to do a new will, she wants to sign the house over to me. Okay, fine. I'd say yeah, but she can't come in, so they fill out the form, and I'm talking to the mom, and goes, okay, Mrs. B, what do you want to do? And she right away says, I want to sign the house over to Johnny. Now, 90% of the attorneys would say, okay, great, I just made a quick $900 fee, I'll do it. But again, I mentioned you always want to do the right thing. He goes, Mrs. B, and I know the answer. How many kids you got? I goes, I got 3. He goes, well, Mrs. B, I understand that when you sign the house over to Johnny, that's your main asset. The other kids aren't going to get anything. Is that what you want? No, I want all of my children treated equally. That's what I thought. Put Johnny back on the phone. I'm not going to do the deed. I'm not going to do this because it's not in that person's best interest. Now, because there's typically no tax when it's going to like close relatives unless it's more than $12.7 million. We don't need to know a lot about people's houses. Maybe the people that have those like nice houses on Darrington Lake got like $12.8 million, but not the regular people. We do ask about real estate. You do want to tell the attorney in the form that any real estate you have, both in New Jersey and any other states. Now, interestingly, I'd say a will transfers assets that do not have a beneficiary. A will cannot change that. So let me give you certain assets pass automatically by title and not by a will. The most common example is when a house is owned husband and wife. Automatically goes to the survivor. So if the husband is owned husband and wife, and the husband came and says, listen, I want to do a will and I want to give everything, this house to my son, not my wife, it goes, well, that doesn't work because it automatically goes to the winner. Bank accounts that are POD, payable upon death, joint account, automatically go to the survivor. A will can't change that. Some things pass by contract. IRA, 401k, life insurance, and brokerage, anything where there's a direct beneficiary. A will cannot change that. So I tell people sometimes it's a good idea after you've done your will to get a printout of not the amounts, but who's the beneficiaries, because I was surprised. I was married for 10 years and I found out one of my life insurance policies, the beneficiary was not my wife. It was still my dad. I assumed it was changed, but assume is always the worst thing. It's like when someone assumed they had enough gas to make it to the airport and they assume wrong and they're stuck on the side of the road, waiting for AAA to bring gas. So when you're doing your documents, before you talk to the attorney, you want to think about, okay, who do you want to get your stuff? Now, and who you don't want to get your stuff. So, let's see. And more people nowadays are not leaving money to children, but leaving it to grandchildren, great-grandchildren. Because to say this, that's it. My kids have their own house. And say, they're doing okay. But they're not really putting away money for the my grandkids' education. So I'd rather have the money go towards their the grandkids' education, maybe for a wedding or something like that. In addition to having dividing up your assets, and I tell people, it's your decision who you want to get, the estate. Some people have what's called specific bequest. What a specific bequest is where you're giving a specific item or chunk of money to someone. So an example of that is, oftentimes ladies will say, hey, I want my jewelry to go to my daughter or my granddaughter because if my son gets it, he's just going to bring the cash for gold and say, what do you give me for this junk? Some of the gentlemen will say, listen, I'm a hunter, I got firearms, I want it to go to my nephew because My daughter doesn't hunt. She's just going to call a place and say, listen, come and get this stuff and get rid of it. Some people have specific, make specific requests to charities, like, to their church, to their synagogue, to the Friends of the East Brunswick Library, to the Elks Club, to the VFW. It has to go to, so there's no tax on it. It has to be a bona fide charity. It can't be to a GoFundMe page. It got to be a real charity. Now, in addition to specific bequests, some people have what I call the reverse of these specific bequests. And that is, I make no request to name a person. You don't put a reason, you don't put a dollar, no request there. And that, again, that's typically your absolute right. Say, we had a client, and when we were doing her documents, and she, she goes, do I have to treat all my kids equally? And I said, well, what do you have? What's your concern? And she said, well, what I've got, one of my sons, I lives on the West Coast, we never hear from him. He goes, well, let me ask you a question. On your birthday, did you get a card or a call? On Christmas, did you get a card or a call? On Mother's Day, did you get a card or a call? No. He goes, well, why leave this guy anything? I'd see, doesn't deserve it, hasn't tried to help you, doesn't appreciate it, and we also know by experience that person's going to be the worst troublemaker after you pass, because they're going to be on the door, 2 days after you die, saying, "Where's my money? Where's my money? Where's my money?" So again, it's your right to write someone out. Some people write someone out, then they can do a new will down the road saying, like, we always want to have clauses to protect young people. It's not just minors. So, they don't get any money until they're 21, could be 25. Because 20-year-olds not only don't do wise things with money, but they'll be influenced by their friends. So if your 20-year-old grandson and 20-year-old child was going to inherit $200,000, their friends would say, hey, you should go over to Maloof and buy a sports car. This is your only chance. And the dumb kid goes to Maloof and says, hey, I just inherited $200,000. I want to get a good car. So you leave money to a 19-year-old, they'll go to Seaside and buy beer with it. Let's see, try to put it towards education. People that have minor children, we put in a clause for guardians for the minors. For the people that have grandchildren, it is a good idea to encourage your own kids to have some type of will there. In the will, like when there's minor children, the trustee is the one who holds the money and can expend as much money as is needed for health, education, support, college, etc. The guardian holds the kids. And you're talking to a client recently. They said, I go, how old is your oldest? He goes, 13. Okay, the idea for this type, we have a trust within the will. They get some when they're 22, some when they're 25, the balance when they're 30, but the trustee can expend as much money as is needed for college support, etc. Let's see, so the kid finishes school, gets a job in another state, and says, hey, Uncle Al, listen, I got a job in Texas, I'd like to get a condo so I don't have to pay for rent. Uncle Al would say, listen, that makes sense, we'll use your parents' money towards a condo. On the other hand, the kid drops out of Rutgers and says, I got to find myself, it's so stressful. I need $80,000 so that I can go on a trip with my buddies. The trustee's going to say, no, your parents did not work so hard so you could goof off, drop out of college. Now, make sure, if you already have a will, make sure it is a self-proving will. If you don't have a will, get a self-proving will. So let me explain briefly what a self-proving will is. Prior to a change in law, person signs the will, then there's two witnesses. But then the two witnesses have to sign an affidavit for for the surrogate or go to the surrogate saying, yes, I was the witness and I was there. Well, so sometimes this witness would say, oh yeah, I'll do my fee's $500. Well, $500? Yeah, or you can spend $3,000 going and do it in front of the Superior Court judge. Sometimes people can't find the witnesses. So there was a law that was changed to say a self-proving will where the person signs, there's two witnesses, then the attorney or notary, and then the person signs again, and there's statutory language pursuant to the Uniform Probate Code. The person signs, two people, witnesses sign again, the attorney or notary signs. That way, the family does not have to locate any of the witnesses. It makes it easier for the will to go to the county surrogate. I mention that because the surrogate says these cheap things online are not self-proven, and it becomes a problem with people trying to find witnesses down the road. We do ask, is anyone receiving Social Security Disability, SBD, SSI? Because sometimes we don't leave money for them in the will, not because we don't like the person, but if someone is receiving governmental benefits and then they inherit a chunk of money, they might become ineligible. Plus, they might not be, the idea is, will the person be able to use and enjoy the money? So we've done wills for someone that says, my one child, he's in a facility in New Jersey, they take care of him, but, he's not leaving the facility, and any money I would leave him would basically go to the state of New Jersey. I'd rather have monies put together to buy things for him, and then even when he passes, I have like some of my charities that would go to. So within wills, there's like sometimes we have a thing called a testamentary trust. When we do the wills, typically I mentioned we email everyone the wills so they can read it. The cost of a will, a basic will is usually $400, $500, and just to get it done. And in a way it is a bargain because not having it costs more in the long run. If you don't change the oil in your car for a long time, you have saved the money on oil, but that makes it worse because the engines get seized up. Let's see. Don't put off having documents done. Let's see. There was a fellow that said, well, I'd like to read up more on this. I goes, sir, you don't have $1 million estate. You don't need to read anything. You have basically. I've already read for you. I went to law school. I go to seminars all the time. I speak at seminars. I wrote a book. I'm not bragging, but when I had my knee surgery, I didn't need to ask the doctor details about how the doctor was going to do the knee surgery. I just smiled and asked the doctor, you've done this before, right? And the doctor at the University Orthopedics was Kenny. I could always do this with my eyes closed. Now, we talked a little bit about wills and sometimes testamentary trusts within the will. Periodically, people ask us about having a revocable trust. And my mother-in-law used to call me every other year. I want to come in and get a trust done. I go, were you watching Susan Orman? She goes, oh yes. It is. Susan Orman is absolutely right. If you live in New York, California, Florida, where the probate process is so expensive, so lengthy, so much work. But New Jersey, typically the probate costs about $150, and for most estates, we're wrapped up in like 3 or 4 months when it's going to blood relatives after we sell the house. So, okay, let me tell you a little bit. And having a revocable trust typically costs you $3 to $6 grand having it done. So I'm really honest with people. I tell people probate in New Jersey is easy, it's inexpensive. Why do you think you need to spend $3,000 per trust? A revocable trust does not protect assets from nursing home or from taxes or anything else. Now, the assets of the estate are not public, so no one knows what they're. A will is a public record, but now if someone says I do want to have a trust done, well that means that you're not going to own the assets anymore. They're going to be owned by the trust. So it means like retitling the bank accounts, retitling brokerage accounts, retitling the mortgage, and it's more than just, a car title you just sign it back. If you're going to transfer a house, it requires a deed, affidavit of title, seller's residency form, affidavit of consideration, let's see, the county coverage sheet, a check of about $150, and let's see, you can't do it. First of all, the mortgage, if there's a mortgage, you got to get permission from the mortgage companies. Let's see, there are some people though have what's called, how can I protect my assets from nursing home? Okay, there's two ways: give it away, or put it into an irrevocable trust. But that means it's irrevocable, you never own it again, and you can't be the main trustee, someone else has to be the main trustee. So, there's no magic way to do things, but if someone says, I want to do that, I want to guarantee it's protected, you're better off spending the money to have a trust than just give the money away to kids. And why is that? Your kids love you, they visit, they help you out. Well, Mr. M had 2 kids, and he goes, hey, I don't want to spend the money in that lawyer stuff. I'm going to give half of my stuff to my son, half of the stuff to my daughter. I'm going to do a new deed. My son owns half my house. My daughter owns half my house. I'm done. I've done. Well, the son suddenly dies. So who owns now half of Mr. M's stuff? His ex-daughter-in-law. Now goes when her husband died, she gets his stuff. So the family says, "Oh, can you give us everything back?" And the wife goes, says, "Do I have to?" He goes, "No, that's your money under the law." And by the way, for the people that are listening on Zoom or down the road, many people that work for companies have something called legal insurance. I'd say where it pays for will, power of attorney, living will, trust if needed. So in New Jersey, some of the 3 biggest companies are MetLife, formerly Hyatt Legal, Aaron Legal, and Legal Access, which some of the Google employees have. So people should talk with their human resources. Hey, do I have a legal plan? Some people sign up for the legal plan for that year just so they can be able to have the coverage for that year. Okay, so you get the will done. Now, you get the will done. What do you do with this stuff? Well, in the old days, the attorneys used to keep it for your safekeeping. Well, the Supreme Court said, no, that's a client's property. That's their property. So when people do it, the original will is your property. I'd say you want to keep it in a safe place where the will, power of attorney, legal will can be accessed. So the best thing to do is just simply buy one of those fireproof boxes at Costco, fold it over, and then put it under your bed where most of the time the bed just collects dust until you move out of the house. You don't want to put it in, and no one's going to be stealing the box and has your will because it has no value. You don't want to put it in the basement in case there's a flood. It should be in a place where Executive 1, Executive 2 can get to it if there's an emergency. Don't put it in a safe deposit box. Safe deposit box is where people put their good jewelry, their gold, their Krugerrands, but the problem is, what happened in March of 2020? Well, the bank's closed to the public for a while. You couldn't go in, so if you needed to go into a safe deposit box, you had to make an appointment. It was a big project, and sometimes a living will or a power of attorney is needed on the weekend or on an emergent basis. So, yeah, it is. Either the executive should know where the original is at, and for some of the older people, they go, so listen, I might as well. Can I just give it to my executive? Yeah, that is your right. Because they're going to need to know where it is anyway. So that's that's our little bit on wills and probate. Now, once you sign the will, we should let, and it's people's decision whether or not to, give copies to all the kids or not say anything at all. If they're not being treated equally, then sometimes it's not a good idea to say anything and let them be surprised down the road. There's no, in the movies, there's the reading of the will. That doesn't exist in New Jersey. Make sure that you read your will before you sign it. That seems pretty obvious, doesn't it? Let's see, but let's see. We story lady our office was helping out with probate, and she goes, Kenny, do I need I got to make some changes to my old will. So I look at the will and I go, Terry, I didn't know you were married. She goes, I've never been married. He goes, well, this says you're leaving everything to your beloved husband, Roger. She goes, I've never been married. Well, didn't you read it ahead of time? She goes, nah, I went to the law office. He said, signed by the ex. Didn't you read it afterwards? No, I didn't read it afterwards either. One of my brothers from my Elks Club says, Kenny, I want to do a new will. They spelled my name wrong. He goes, John, you didn't read it ahead of time? He goes, nah, we signed it at the bar. It was dark. I really did. And it wasn't a complicated name like Gosh Gagarian. You would have thought he would have read it ahead of time. So, okay. We've also talked about revocable trust is the ones that the trust salesmen say, oh, avoid probate. Probate's the devil. But New Jersey, not even. If you move to Florida, California, don't even buy the property in your name. Have a trust set up and put it into the trust before you even buy it. That way you're avoiding that extra step of doing an extra deed. Oh, and by the way, for anyone, typically our office now charges a $200 consult, but if anyone attended any of our programs, either live or in person, within 30 days we do a free consult. Now, let's see. A will, once it's properly signed, does not need to be updated unless you believe that you want changes to it, or there should be changes to who the executor or the beneficiaries are. So if you did a will this year, it's still good 25 years from now. But the question is, can the executor still do the job? So our rule of thumb for someone to be the executor is three things. I'd say, can they drive to New Brunswick, to the county surgeon's office? Can they park in the circular parking deck, which is a real hassle? The word, within 1 week of the parking deck open up in New Brunswick, you can see all the smashes on the side of cars. Can they then go down in the elevator and walk up the hill? Because there's no handicap parking by the circuit's office of the county courthouse, none. And how do I know that? The time that I was on crutches. I go, hey, there's no handicap parking here. And just like I asked, the other thing for the executor is, can they walk into a bank and do stuff? I mean, we're not anti-old people. We're not anti-people that don't speak English, but we're trying to be practical, and I'm trying to save people money. So you do want to take out your will every 5 or so years. Okay, is this still what I want? And can the two executors still do the job? Now, I'm going to talk in 1 minute about powers of attorney, but we do recommend a new power of attorney be signed every 5 years. The reason why is because if someone brings a power of attorney to the bank and says, listen, I need to go do some banking for mom, and the daughter shows the power of attorney, the bank goes, who are you? I'm her daughter. Or your idea is different. Oh, I got married and I moved somewhere else. He goes, well, what, you're telling me trust you? I'm not going to honor, I can't honor this. This says the power of attorney is, Kathy X, who lives on this street, and you're showing me a document that says it's Kathy, different name, that lives in another state. No, so, part of the planning is this. So, let's see. What's a power of attorney? A will takes care of your assets if you pass away. A power of attorney takes care of is while you're alive, but you're giving the power to a family member to make sure that can act legally on your behalf. It's a formal document. Interestingly, the banks also remind people, it got to be done formally. And there was a while back, some of the banks were giving people a hard time, and they would say, "Well, it wasn't done in our form, so we're not going to honor it." So the legislature of New Jersey came up with a revised power of attorney statute, and it said, "Hey, if the bank has it has reference to the New Jersey statute, then the bank has to honor it." However, it had to say, the power of attorney itself had to reference Section 2 of PL 1991, C95, C46:2B-11. And, we know that these cheap forms online aren't going to make reference to that New Jersey statute. Periodically, though, let's see, we get in a fight with a bank. Oh, we're not going to honor the power of attorney. Why? Well, what's that our fault? Well, the law says you have to. Well, no, our policy is no. Don't tell me what your policy is. The law in New Jersey says this. And then some person that took a 1-hour class at the bank says, the law is this. Then sometimes I get it. Goes, listen, don't tell me what the law is. This is what I do for a living. Tell you what, why don't we instead file a complaint with the Department of Banking and have them deal with it? So, in your power of attorney, you want to do clause real estate, banking, and we've revised our documents over time to include a medical access where the family person can have access to the medical records under federal HIPAA to make decisions under the pulse, and also your designated caregiver under the New Jersey statute. Now, once the power of attorney is signed, it is a good idea to have either you or a family member scan it and send it to your financial advisor, your accountant, your life insurance person, anyone who deals with your money. This way, it's already in their records, so that if all of a sudden there's an issue comes up, it is already there, and they can't say, "Well, we don't really know about this." Let's see. New Jersey created recently a designated family caregiver, so we added that into our powers of attorney. The last document I am going to talk about is the living will, also called advance directive, medical proxy power, medical power of attorney. So, think of the living will document really isn't for you; it's for your family. Let's see, because the living will is really someone's in a coma, irreversible condition. They can't talk for themselves. So I'd say you're giving instructions and information to the hospitals and doctors what your wishes are. I'd say it was about 20 years ago. It was the Terry Schiavo case. She did not have a living will. Went to the United States Supreme Court, where the husband said, "Listen, the doctor says she's brain dead. We want court permission to withdraw the feeding tubes." And her parents said, "No, there's always hope, even though it's so long time." And so the idea is that you want to have a living will, and again, it's not for you; it's your family. So your family is not put on the spot. Because I remember one time when a doctor said, for someone who did not have a living will, should today be the day? Should today be the day that we remove life support and the person dies today? And I remember the doctor said to me, "Geez, I feel bad." Now, it wasn't even a family member. I was the power of attorney, but You know the right decision is for someone who's 92 years old that's not going to open up their eyes again and leave the bed. But you hate to be the one to say, okay, let's end it today. I couldn't even do that for my other dog when my dog was on its last day. I had to send my wife into the room. So the idea with the living will was that you're giving instructions to hospitals and doctors what your wishes are, and you're selecting one captain of the ship that if there does have to be a decision, or the doctors talk to someone's in charge, just like the executive in the will, the agent in the power of attorney. In your living will, Section A, fluids and nutritions, either to be withheld or provided. I'd say, so probably 80% of the people say, listen, there's no hope for me. I don't want to have feeding tubes, etc. Put on them. The next section deals with directive as to medical treatment. I usually see artificial machines. 99% of people say, listen, there's no hope for me. Then end it. Don't keep me in some hospital just with a machine if my eyes are closed. Let's see. We revised our living wills to include the HIPAA authorization. And you get to pick who you want. Some people don't have the same person as the executor as their number one agent in the living will. Sometimes it's someone who's more involved with, knows more about medicine. I'd say, but you also want to have someone that can make the tough decisions if a tough decision has to be made. Let's say, for the married people, you remember when you were first married, everything's all lovey-dovey and everything's great. Well, when I was redoing my documents when I was first married in 1989, my wife says, oh, I can never let them pull the plug on you. Okay, fine. I'll just leave my dad because he's logical like Mr. Spock. So then 25 years later, my wife says, so wait, answer my quick question. If you get dead, I get $850,000 tax-free through life insurance. I can quit my job and I never have to work ever again. Oh, kill you now. And we also have a clause in the living will that the organ donation yes, organ donation no. I recommend everyone, no matter what their health, age, whatever, check off the box. We want, there's no maximum age to be an organ donor. There's no limitations on health to be an organ donor. And a fellow, said like, I'm 85 years old. What's good on me? And I said, cornea. He goes, cornea and skin. And if I was in a fire, I might have old guy's skin and something got burned off my body. Once you sign the living will, it is a good idea to have it scanned and emailed to you, to your family, and also to your doctors, so that this is a federal law that says you go to the hospital, you have it. This way the doctors have it. Okay, our last topic before I bring up our next speaker is probate. Let's see, who would think that probate in New Jersey is so easy? Let's say I mentioned the circuit needs the original will, a death certificate, check for $150, and we fill out the circuit probate form. We first fax them the papers, and then if they say it's good, then they send us some other papers to sign. We send it into the circuit, mails the papers to us, and then no one has to drive to New Brunswick and have their car smash around the parking deck. Then we send out a notice of probate to all the beneficiaries. The will was admitted on this date, this time. You're listed as one of the people. A copy of the will will be provided upon request. Typically, we send them a copy. We set up an estate account, get a tax ID number, sell the house, liquidate assets, and then at the end, although there's no inheritance tax, it is going to children, spouse, grandchildren, stepchildren. We do sometimes have to file the return. If it's going to brothers or sisters, the tax at 11%. No tax going to charities. If it's going to everyone else, the tax is 15%. And Trent's now taken 13 months just to take it off the floor and look at it. So I tell him that some of the probate matters, he goes, this is the logjam, where I'll say, listen, let's file it as soon as we can, even if it's incomplete. That way, we're online, kind of like at Disney. You can get online, let's see, you're online, and then some of you kind of, your spot's holding, you want to run out and use the bathroom. Once the estate is wrapped up, the attorney prepares release of our funding bonds, we send it to different beneficiaries, because, okay, if everyone signs this in front of a notary within like the next 3 weeks, everyone will get their check in 4 weeks. But if everyone doesn't sign, then we gotta go in front of a judge, it's gonna cost a lot of money, drag everything out by 6 months. If it's with one of the family members that doesn't sign, then we send a letter out to everyone else saying, we got all the release of funding bonds in, except from Brother X in New York. And that means that until he signs, no one gets a penny, even if you've all good people signed, and then we have to go in front of a judge, and that's going to drag everything out even more. And this, by the way, the one who didn't sign, his phone number is this, his email is this, and this is where he lives, so you can go knock on his door. So probate in New Jersey is not complicated. My office is in Edison, New Jersey. My name is Ken Vercammen. I'd say years ago I had printed these Brunswick fancy folders for when people saw me. But after the program, I'll stay around a little and answer questions. So, but what I also like to do is, I like to bring in someone that is smarter than me to talk about some of the common financial money mistakes that people make. And so I'm now going to have come up my friend Dave Solenko, who by coincidence has an office in Middlesex County. And Dave, what did you used to do? Come on up, Dave. What did you used to do before you became this financial planner kind of guy?
I was a trust estates attorney.
He was a lawyer. But he goes, sometimes you like doing what you're doing. And a person asked me 2 weeks ago, Kenny, when do you think you might retire? It was about 25 years. 25 years. It was. I'm spending my time preparing some documents and talking to nice people. It's not really work. But that's why I'm not running around going to the Wanneroo Municipal Court on a Thursday night, spending hours in the car. So anyway, Dave, tell them how they can help protect themselves. And you got to look into that screen.
I know. Good evening, everybody. Good evening at home, everybody.